Welcome. This is the Employment Law Channel. I'm Scott Drake, and today we're going to be discussing pay and incentive compensation issues. My guest is Larry Moy. He is partner with Outten Golden and co-chair of the Financial Services Industry Practice Group. Larry, a great pleasure. Good to see you again. Welcome back.
Thank you very much.
So what are the most common problems that people coming to you have regarding bonus pay or incentive compensation or just pay issues in general?
Well, probably the simplest and most common problem is people who simply haven't been paid. Oftentimes it comes in the form of people who have worked an entire year or most of the year and weren't paid the bonus pay or incentive compensation that was promised to them. Sometimes it can be even as basic as not even being paid their base pay or base salary, but a lot of times it focuses on not being paid their bonus or variable compensation. Another issue is people come in with us all the time to basically make sure that whatever they understood the deal was going to be and how they were going to get paid, that it's actually paid in that form. In other words, that their contract or that their offer letter, that the terms of that actually match the terms as they understand them.
Larry, we've all heard of people who've been let go from a position just before attaining a retirement vesting threshold or something like that. And I suppose that can occur with a bonus as well. Can you talk about that?
Well, the answer is yes. I mean, it can actually, your question's a good one, Scott, and it actually breaks down into two types of scenarios that we see. One scenario is people who are let go close to a retirement age or some other critical vesting period, such as they're going to have deferred compensation or they're going to have a substantial pension benefit that vests at a certain time, and they're let go coincidentally right before that vesting obligation hits, which would be a big financial obligation and big financial hit for the employer. Another thing that happens is on a kind of a smaller scale, if you will, or at least shorter scale in terms of duration, is someone works the entire year and then they're let go just before Christmas, or even after the entire year is done, but just before the bonuses are actually paid. That's another common problem. The first step, we always try to give the employer a chance to make it right, and we've sometimes counseled clients through negotiations if they feel they have for whatever reason, a good enough relationship, even with the firm or employer that let them go, to perhaps try to negotiate on their own. As you can imagine, that's not always possible. Oftentimes we come in right from the get-go and start negotiating with the employer or the employer's lawyers and trying to have the employer realize its obligation, but oftentimes also it ends up being something that ends up in litigation. And so the litigation for many of our clients who are in the securities and financial services industry will actually be an arbitration, either at FINRA or the American Arbitration Association, for example, or a private organization, a private dispute resolution organization. And sometimes it resolves itself through a court lawsuit, litigation.
Larry, does the chance for success in this type of case depend on what field the person is working in?
I think the answer to that question also, Scott, is yes. It can depend on the industry to some extent. There's multiple reasons. Obviously, it's kind of a highly individualized situation. Some industries are under more financial stress. It's harder to negotiate a resolution with them. It's more likely that you're going to have a litigation with them. Some industries, as I said, such as the financial services industry, there is a dispute resolution program through arbitration. And in those arbitration situations, you have different deciders, if you will, than you have in court. It's not a judge, it's not a jury, it's arbitrators. It's a different type of what we call forum. It's more equitable in many instances, and so whether someone is treated not just according to the letter of the law, but according to what's equitable, what's fair, might have more impact in arbitration, but one way or another, it oftentimes impacts the outcome, and that forum, and which forum you're forced to litigate in, is a function of what industry you're in. So that follows from your question, Scott.
Now, I'm sure that this can vary state by state, but what are some of the issues that come up relating to the non-compete clause in a contract or an agreement?
Sure, absolutely. And to kind of follow on your prior question, Scott, it also, to some extent, depends on industry as well. Some industries are much more aggressive in terms of the employers insisting on non-competes. Some industries, such as law firms, for example, we also represent lawyers. And lawyers are not necessarily held to non-competes as vigorously because of ethical rules and professional obligations as some other industries may be. But in any event, you know, these issues come up all the time with respect to employees who are obligated or have signed a piece of paper, sometimes not knowingly and sometimes without really any consideration that binds them or supposedly binds them to, you know, a lengthy garden leave provision where they have to give extremely long notice before they're even allowed to effectively resign. And then after that period, oftentimes there's a desire on the employer's part to impose a non-compete provision or non-solicitation provision. Some of those provisions aren't enforceable for a variety of reasons. Others, even if they are enforceable, they're too lengthy, they're too restrictive, they don't provide compensation during the restricted period while at the same time depriving an employee or an individual of a livelihood or ability to earn a livelihood. And so those issues you know, come up quite often.
Larry, let's talk briefly about some preemptive measures an employee can take to prevent this kind of problem from happening.
Well, the most fundamental you know, preemptive measure that any individual can take in this type of situation is to be careful on the way in. You know, that's your honeymoon period. That's the point where the employer is going to be most willing, and more willing at least, to engage in a discussion about what the appropriate restrictions should be, even on the way out. By the time you get to the way out, a lot of times the relationship is fractured and not in the same state, and it's much harder to try to work out a compromise solution or to deliver concessions or obtain concessions. So on the way in is your chance to make sure that the non-compete or garden leave provisions, if they're in your document, they're not overly restrictive. To make sure that if you have an understanding with the business folks that you're negotiating your deal with, how you're going to get paid, that the document actually delivers in that manner. And for that matter, it's at the beginning where you have some control, perhaps, hopefully, based on your negotiating leverage, over deciding how disputes are handled at the end of the road.
Larry, in closing, do you ever start lawsuits over a bonus?
Unfortunately, and I say unfortunately because obviously it is a last resort, but it's a last resort that many employees and individuals have to take. And we have a lot of experience doing so, and you know, obviously that experience covers all of the different forums that we talked about. So both in court, before the American Arbitration Association, before private organizations like JAMS, oftentimes before FINRA, which regulates and governs dispute resolution for financial services professionals. We're bringing those types of claims all the time.
All right, Larry, great. Thank you so much.
I appreciate it, Scott. Thanks very much.
My guest has been Outten Golden partner and co-chair of the Financial Services Industry Practice Group, Larry Moy, and you're watching the Employment Law Channel, a division of the Legal Broadcast Network.